When I was a student in college, I did not have a particular interest in going to law school. This was in 1968, the height of the Vietnam War, and there was one more year of graduate student deferments from the draft. And so most of my classmates and I were looking to find something to do in graduate school to avoid the draft. And both of my college roommates had decided to go to law school. I didn't actually know anything about law or law school, but I decided to apply. And I applied to a bunch of different law schools, and I was accepted to them. And I decided to come to Chicago really for only one reason. My girlfriend at the time was moving to Northwestern, and I wanted to be in the same city as her. So I said, okay, what the hell, I'll come to Chicago and go to law school here. And I didn't really know what to expect, frankly. But very quickly, I decided that I enjoyed and indeed loved being in law school. I should say, by the way, my girlfriend broke up with me shortly after I got here. But the fact is, my classmates were just wonderful from day one. They were smart and lively and interesting and engaged and challenging, and the classes were fascinating. The quality of the teaching was terrific. And many of my professors are people who, to this day, I admire enormously. And so I didn't know what to expect, but what I found was that I loved the experience of being a law student and loved being here. I didn't really have any particular interest in being an academic. When I was a law clerk to Supreme Court Justice William Brennan, I was considering two different jobs in January of that year, January of 1973. One was working for Senator Edward Kennedy, because I hoped he would run for president in 1976, and the other was working for the Center for Law and Social Policy. And then I got a call from one of my favorite professors here, Owen Fiss, who was chair of the Faculty Appointments Committee. And he said to me, I want you to come out and interview for a job here. And I said, Professor Fiss, I'm very flattered, but I don't really have any interest in being a legal academic. And he said, you'd be great at this. Trust me about this. You'd really love it. And I've never been very good at saying no to people on anything. And he called several times. And finally, I said, okay, I gave in. I'll come out and do that. But because I didn't actually want the job, I decided to take an approach to the visit that was intended by me not to make me very appealing as a candidate. I first of all decided to disagree with all of the faculty members in my interviews with them about everything, and to be pretty brusque about it. And I also decided to give a presentation to the faculty on a crazy topic, which was that heroin addicts have a constitutional right to purchase and possess heroin, which I thought the faculty would regard as ridiculous. And I remember getting on the plane to fly back to Washington and thinking, I can't believe I blew it. I had a great time. I should have done this the right way. And to my amazement, several weeks later, I got a call from the dean, Phil Neal, offering me a position. And it turned out that I had completely inadvertently come across the right strategy to get a job here, which is to be disagreeable and problematic and challenging. And I did exactly what they were looking for without intending to do that. In my early years of teaching, I was a bit of a hippie. I had long hair and I didn't wear a tie when I taught. One of the things that was quite fascinating about coming back and joining the faculty only 2 years after graduating is that the students were basically my peers. And from that standpoint, I developed relationships with them that were much more personal than I ever would have expected. And that was very satisfying and engaging. And I'm still in touch with many of the students who were in my first classes in 1973 or 1974, and value them to this day as friends. Looking back on my experience, I would tell my younger self, be thankful that you made the decisions you did, even if you didn't think they were the obviously right decisions. You lucked out. And I never would have imagined that I would be here 50 years later. I thought when I joined the faculty, this would be something I'd do for a couple of years and then move on to something different, government or whatever. But I would basically, looking back on that, I would tell myself, you were extraordinarily lucky to have been called by Professor Fiss and then invited to join the faculty and made the wise decision to join the faculty, even though at the time I wasn't at all sure it was the right thing to do. But I would say, looking back, that I was extremely fortunate to have made those decisions, even though I didn't at the time know that they were the right ones. The reason I've been here all these years is that I love the institution. I love teaching. I love scholarship. Uh, my colleagues are just terrific. I mean, they've changed over the years, of course, but the intellectual community is challenging and interesting and engaging. And I very much value the goals and values of the law school and of the university generally. And I've rarely thought seriously about leaving, but to the extent I've had opportunities to do so, I realized that it's not what I wanted. So one example was after I finished being provost of the university, I was seriously being considered to being president of the University of Michigan or Brown University. And in both instances, I decided to withdraw because I realized even though they were excellent institutions, they weren't this institution. And this was the one I loved, and this was the one I wanted to be at. So I've never regretted not leaving. The community here is special because people are engaged with one another. In most other law schools, uh, faculty members are present relatively infrequently. And I have visited at other law schools, and that's exactly the reality. They come in when they have a course to teach, or maybe if they have a workshop that they have to go to, but they basically tend to spend a lot more of their time not in the office. Here, faculty are here almost all the time, and they're engaged with one another, and they're working with one another and talking with one another. And that's a major part of the culture that in this institution, uh, people challenge each other's ideas and their views, and they do it with respect, and they do it in a way that is constructive, and it helps to make the scholarship and the thinking of people better. And nobody, to my knowledge, in my recollection, has ever been rude about it. It's always been, okay, I disagree with you. Let me tell you why I think you're wrong. But it's always been understood to be a constructive conversation designed to enable you to do better at what you're trying to do. And so that kind of engagement is unique to this institution, both as a university and as a law school. And it's what I think makes it special in many ways, not only in terms of the productivity of the faculty and the quality of the scholarship, but also in terms of the intellectual culture and the day-to-day life of faculty and students. When I think back about my experience here, um, one memory I have and think about often uh, was when I first arrived as a student in 1971. Um, I was sitting in the library before classes even began with a classmate of mine, and we were talking. And second and third year students at that time were coming by and basically saying, "Oh, you're really in for it. It's going to be tough and demanding," as it was. And then this one fairly young guy walked past and he said, "Oh, I see the new crop has arrived." And I looked up at him thinking he was a second or third year student and said, "Fuck you, buddy." And then I looked back at my classmate and he was horrified. I said, "What?" And he said, "Don't you know who that was?" And I said, "No." He said, "That was Professor Hazard." And I said, "Who's he?" And he said, "Well, he teaches us civil procedure. And he is, I am told, the most demanding, the most rigorous Socratic teacher in this institution. And you just put yourself in an extremely dangerous position, having said what you did to him." And uh, in fact, I was terrified. And I was probably the first member of my class to be known by almost everybody because of that incident, because the person I was with told people and they kept telling people and they couldn't wait to see what would happen. And one of the things that was fascinating is Professor Hazard, who was in fact the most demanding and brutal Socratic teacher in the law school, tended to call on students in rows, either horizontally or vertically or at an angle, and he kept skipping me. And it was just terrifying. And the last day of the civil procedure class, I expected he was going to come after me, and he did not. I was the only one in the class not called on 6 times. And I ran into Professor Hazard several years later after I joined the faculty. And he had left Chicago at that point. And I said, "Professor, you probably don't remember me." And he said, "Of course I remember you. You were my favorite student of all time. I loved torturing you." So, that was one of my favorite memories. And another one of my favorite memories was when I was a new faculty member, I was writing my first article. And it was in constitutional law, which was the field I was most interested in. And it was about an issue of equal protection. And I did a first draft of it, and I gave it to Professor Harry Kelvin, who taught me constitutional law. He was one of my favorite professors. And he took a look at it, read it, and said to me, "Jeff, I don't think this is great. I don't think this is going anywhere." And I was just heartbroken. And he said, "But I have an idea for something for you to write about." And it was an issue about free speech, which is what his specialty was. And I wrote that piece. It was the first article I ever wrote as a faculty member. And it put me in the direction of my whole career, which was to focus on free speech and freedom of the press as a central part of constitutional law. And so that moment was critical in terms of determining who I wound up being in terms of my scholarship. One other favorite moment was when I was done being provost of the university after 8.5 years and decided to return to the law school. um, I was interviewed by a reporter from what was then the university's newspaper. And he came to my office in the provost's office, and he said, among other things, "You must be very excited to be getting back to the law school and have the opportunity to do scholarship. What are you going to be writing about?" And the truth is, I hadn't really thought very much about that because I've been too busy doing other things. And I couldn't tell him. I had no idea what I was going to write about. This was right after 9/11. And so I said to him off the top of my head, "I'm going to write a book about free speech in wartime." And he said, "Oh, that's great. That's a great idea. That's wonderful. That's exciting." And I said, "Whew, glad I avoided that." But then when we published the story, that was a major piece of it. And I got hundreds of emails from faculty members across the university saying, "Oh, it's great that you're going to be writing about that. It's terrific. It's really important." So I came back to the law school and sat at this very desk and started thinking about, well, let's see, what would I write? And after a week or so, I just said, I don't know what I'm going to write about this. I don't really have anything clear in mind. And I went that week to the faculty roundtable, in which faculty members every Monday, Wednesday, and Friday get together for lunch. And I sat down, and Cass Sunstein, my colleague at the time, said, "So, Jeff, I understand you're going to write a book about free speech in wartime. Tell us about it." I wanted to kill him. And I said a bit about it, and then we had this great conversation with about 14 of my colleagues about the topic. And that gave me ideas that I hadn't actually come up with myself. And I wound up writing the book, and it won all sorts of national awards. And it got me back into the world of being a full-time scholar and academic. What were my favorite career moments? I would say basically one of them was being dean. I loved the opportunity to be dean of the law school. Um, the law school was in good shape at that point, so there were no crises that I had to deal with. Um, but I managed to do a number of things that I think were very beneficial to the place. We created the second ever law student journal, the Legal Forum, at that time. I also created, when I was dean, the Midway Dinner, which is the dinner second-year students have every year across the Midway. And the reason for doing that was not only to mark that they were halfway through the law school career, but also to remind them that they were at a university and that they should not be focused exclusively at the law school, but they should be aware of all sorts of things at the rest of the university, not only courses, but also theater and music and the like. And so that was the main reason for it. I'm delighted that it's still going on. I was very happy to have been able to appoint some great faculty members. Elena Kagan was one of them. I brought Barack Obama here to the law school, and many other faculty members some of whom are still here, like Randy Picker, others whom are all around the country in various different ways. Another major career moment for me was being chair of the committee that wrote the University of Chicago Free Speech Principles, which we did almost a decade now, and they've been adopted by well over 100 colleges and universities, and particularly critical today, given some of the issues that have occurred on campuses. And that was something that was very satisfying and beneficial. Another thing that was very important to me was President Obama asked me to serve on a national security committee after the Edward Snowden leaks of national security information, with 4 other people. And I spent most of several months in DC working on a report that made a number of very strong recommendations, almost all of which have been adopted, about how to deal with issues of national security and freedom of expression and the like. So that was also a great moment in terms of my career. in thinking about my career here, one of the things I guess I would say may have been most important was creating the work in progress. That has fundamentally changed the culture of the law school and has improved the scholarship of the faculty and has brought faculty members together in a way, not just if I'm writing an article, I will give it to my 3 or 4 colleagues who are interested in the same thing I'm interested in, but everyone gets a chance to see it and to comment on it. So I guess I would say that the single most important thing I'm most proud of is creating the work in progress. Had I not done that, this would not have been as exciting and energetic an institution as it is today. So one other thing I did that I'm very proud of is creating what I have called the Constitutional Decision Making Seminar. I created that the first year I joined the faculty. And the reason I did so was because having been a law clerk, particularly at the Supreme Court, I realized that writing opinions was a whole lot more difficult than I may have thought it was. Because in class, taking courses, the professors would challenge the reasoning of the opinions all the time. And that led me and others to think, well, these judges aren't really all that smart. But then when I was a law clerk, I realized writing opinions was a whole lot harder than I thought it would be. And so I wanted to give students the opportunity to share that experience. And so what I created in the seminar was a program in which students sign up in courts of 5. I do it on different topics each year. Usually I do it on equal protection because that works the best. Each week, the courts, all of them, get 3 cases, hypothetical cases, raising issues about the meaning of the Equal Protection Clause. They get 2 cases each week. They have to write majority concurring dissenting opinions in each of the 2 cases. They cannot rely upon or invoke any real Supreme Court doctrine. So they're starting from scratch with the first cases, but those become precedents for the subsequent cases. And over the course of the, typically it's 18 cases, they develop a very complex jurisprudence. And I think it gives them a terrific understanding of the reality of what it means to be a judge or a justice and the challenges that imposes. And so I do think that's been a real contribution to the lives of many of the students who've taken it. And I'm teaching it now this quarter again for probably the 40th time. I would say the biggest change in legal education over the last half century is that when I was a student and when I joined the faculty here, legal education was about thinking. It was about teaching students how to think about hard questions and not so much to learn the law as such, and not so much how to practice law, but how to learn the intellectual skills that lawyers need to be creative and original and effective. Over time, what's happened is that there's been a significant shift in many law schools, including to some extent here, towards more practical hands-on courses taught by adjuncts, designed to teach students not only the intellectual skills, but also the skills of actually being an on-the-ground lawyer. And that occurred mainly because law firms, who used to be perfectly happy hiring young entry-level lawyers who knew nothing about practicing law, but were smart and curious, they were perfectly happy to teach them how to be actual on-the-ground lawyers in the way they wanted them to be on-the-ground lawyers. But over the years, they've decided that they didn't want to do that. And they wanted people to be able to hit the ground with a much greater capacity to actually be on-the-ground real lawyers. And so law schools, in order to make sure their students had the opportunities to get the jobs that they wanted, had to accommodate those expectations. And so in almost all law schools today, there are many, many, many more courses that are being offered second and third year students that are quite different from what was offered when I was a student. When I became dean, there were only 3 adjunct professors at the law school. I don't know what the number is today, but it's probably 20 times that. And I understand why we need that because of what the firms want. They want people who are capable of actually entering legal practice and being lawyers, not just being smart and curious and intellectually engaged. But I do think it's a dramatic change in the quality of legal education. Less so here than it has been in most other institutions, but even here to some degree. In terms of thinking to the future of the legal profession, um, what makes me most optimistic is that I think lawyers have been taught to be smart and thoughtful and open-minded and to be rigorous in your thinking. And I think that that is essential to a democracy, and that lawyers need to play a central role, as they always have, but maybe even more so today than before, in helping to educate the public, in helping to educate public officials, and in shaping what our society believes and thinks about. Because I do worry that in a world of social media, too many people are not being exposed to the kind of critical thinking that is essential to be good citizens in a democracy. And lawyers are the best trained people to do that. And I think they need to be more active in terms of organizations that they are part of to present that to individuals and not let it disappear. I think there are two major challenges facing free expression in our democracy today. One of them is the impact of social media, that individuals hear and read and see only those things that affirm their beliefs already. Facebook and other entities simply send you more and more and more things like the ones you've liked. And you're not exposed to competing views in the way that you were in the past when you got your information from newspapers and magazines and television and radio and so on. And I think that's very damaging to the culture of a democracy. People need to be open to hearing and thinking about a whole range of competing views. That's how we function effectively in a democracy. And so I think that's a major challenge. And the issue is, what do you do about it? I mean, is there some solution to that that is viable and that even would be consistent with the Constitution? But I do think that that's increasingly a challenge. Um, and the other aspect of social media that's troubling is that it deters people from speaking openly about controversial views. I mean, it used to be that you could say something about a controversial view, and you would be saying it to the people around you, and you could argue with them about it, and that would be that. But today, they can post it on social media, and you know that it's accessible to far, far more people. And that means that if it's controversial, it may get you in trouble. And so I think it means that people are much more unwilling to be as open-minded and as aggressive in their views as they should be in a free and open society. So that's troubling in terms of free expression. The other is the impact of money in politics. The Supreme Court has opened the door to unlimited impact of corporations and the wealthy in terms of shaping our political system and our electoral system. And I think that was a terrible decision in Citizens United that the Roberts Court made. It overruled a whole stream of prior decisions, and it creates a huge challenge to not only democracy but to free expression. The idea is that the wealthy should not have that much of an impact upon what we hear and what we know. And now that's gotten way out of hand, and it's going to get worse, given the current Supreme Court. So I think that figuring out how to deal with that is a real challenge. In fact, Lee Bollinger, the president of Columbia, with whom I've done many books, and I are now in the process of putting together a book on money in politics. And we think that's really a critical issue as we go forward. I often ask myself, why do I keep working on books? What's the point? And I think it's mainly because I believe that I'm in a position, particularly books that have essays by other people, that I'm in a position of being well known to attract others who are also important and well known to agree to write essays about important subjects. And so in the last several years, most of my scholarship has been along those lines. It's been mainly with Lee Bollinger, the president of Columbia University, who was a law clerk with me at the Supreme Court that same year. And we've done, I don't know, 4 or 5 books like this already. And the idea of it is to basically bring together terrific scholars and lawyers and historians and political scientists and others to contribute essays addressing highly complicated and important issues in our society. I honestly don't think at this point in my career I'm likely to be a terrific original scholar. I think I'm kind of past that point. I would say that the best book I've ever written is Perilous Times, Free Speech in Wartime, which is a very rich history of the evolution of First Amendment jurisprudence in our country. And one of the things it does is to make people aware of the fact that the state of free speech today is not what it was in the past, and that it's important to be aware of that. And as I said, it won lots of national awards, so other people thought it was very good as well. But I would guess that's probably my single greatest accomplishment in terms of writing a book. Another book real book that Lee Bollinger and I published recently is on the issue of affirmative action. And we both are strong supporters of affirmative action, and we're concerned that the current Supreme Court would do what it ultimately, in fact, did do in the UNC case. And so this book, which was published several months before the court decided that case, made the argument similar to the ones that the justices had made for almost half a century up until that decision, that affirmative action is constitutional, that it is essential, and that benefiting those individuals and citizens of our society whose groups have been the victims of a history of long and often terrible discrimination is a legitimate thing for a society to do. And unfortunately, the majority of the justices in that case rejected all of the precedents and rejected the arguments that we put forth, and essentially held that affirmative action was unconstitutional. And but the whole point of that book was to present the opposing point of view, and the dissenters cited it a number of times, but unfortunately it was only the dissenters. If a law student came to me today and asked my advice, what I would say to her is to have an open mind, not to think that she knows what's right and what's wrong and what's good and what's bad about any issue related to the law. That the way we become with lawyers and the way we become good thinkers is to be open to hearing different points of view. If one thinks about our society, for example, in the past and how we've changed, there's lots of major changes that I think are very positive and that came about only because people were willing to be open-minded. Gay rights is a classic example. Women's rights is another example. And I think that for lawyers in particular, it's important to always understand that what you think is true may not be true, and what you think is right may not be right. And to be open to hearing competing points of view and arguments, I think that's essential to anyone who wants to become a lawyer. If a graduating student sought my advice, I would basically give her the similar advice to what I give a new student, which is to keep an open mind. And don't assume that you know what you will want to do for the rest of your career. There are so many opportunities that you will have, and it is important to be open to them. And in the same way that my career was not something I expected to be as a legal academic for half a century and more, I think the advice I would give is to be open to alternatives, whether it be government service or public interest or corporate law or whatever, but not to assume that you know what you're going to be doing when you graduate law school. You're still very young and inexperienced, and you should keep an open mind, and you should seek the opportunities to pursue other avenues, not just focus exclusively on what it is you're doing when you graduate as a lawyer, but to be aware of and be engaged with other opportunities that might, in fact, move you in different directions. It's interesting to me that I've been on the faculty longer than anyone else in the history of the law school. And I'm not sure what that says about me, but it does say something about my commitment and admiration for the institution. I think that in thinking about where I am today, I am just so very proud of our law school, about how it has grown over time and strengthened the values that were central to it from the time I first joined the place. And I think that what I would say is that my single greatest satisfaction has been a member of this community, both the law school and the university, by the way. And that I think that it's a totally distinct law school and university in ways that are fundamentally important to what I believe and to what we should believe.